start in order with Watt versus Florida. Counsel can come up and begin when you're ready.
Good morning. The outset, we would ask to preserve 5 minutes for rebuttal.
Okay, I'll try and help you keep your time.
May it please the court. My name is Carlos Ivanor, and I'm here on behalf of the state of Florida. The state of Florida would argue that the trial court erroneously granted the motion to suppress, and that the search warrant was actually had probable cause to be issued. And furthermore, the good faith exception should apply if the search warrant was not valid. Start with the facts, what the affidavits for a search warrant stated. Confidential informant advised Brevard County Sheriff's Office Special Investigations Unit that Mr. Simpson and Watts sell large quantities of cocaine in and around the Brevard County area.
Mr. Ivanor, let me ask you this. We've read the affidavit, the search warrant affidavit, so we all are working from the same page.
Yes.
The trial judge seemed to be concerned that there was nothing that connected the residents with the alleged drug dealing activity, all of which took place off premises. Why don't you focus on what facts in the search warrant affidavit you think lead to the conclusion that there was some connection between the residents searched and the drug dealing activity?
Okay. Well, after the confidential informant advised the police that the residents of Watts and Simpson were the ones that were selling cocaine, the police then started surveilling the residence and observed that Mr. Simpson would exit the residence. On 2 different occasions, which was on February 10th and February 16th, the police actually surveyed as Mr. Simpson left the residence, locked the residence, and then would meet the drug buyers, confidential informants, and provide certain different amounts of quantities of cocaine. Our first argument is that the search warrant contains sufficient facts to reasonably infer that the items to be searched were at the Watts residence. Now, in order to...
Well, the trial judge seemed to be concerned that you couldn't infer more that the drugs came from the house than from being stored in the vehicle.
Yes, well, our argument would be that, in order for a search warrant, it must be based on probable cause. There must be a commission element and a nexus element. Nexus element, the evidence is relevant to probable criminality. It's likely to be located at the place to be searched. And I think the nexus element is, of course, there. And, case law out of the Fifth does say that all you need, this is out of the State v. Wheel case, for a search warrant to be valid, it is not necessary that there exists direct proof that the objects of the search are located in the place of the search. Rather, if there is a probable cause to believe that someone committed a crime, then the likelihood that the person's residence contains evidence of the crime increases. And that's basically what the State of Florida...
Wouldn't that theory allow you to get a search any time for a drug dealer's house?
Well, not any time. I mean, in this case, I think that the facts are strong and show that there was...
The facts are that the drug dealer lived at the house and left the house and was seen leaving the house. Why would that be any different than any other drug dealer's house?
Well, the affidavit does say that they were moving large quantities of cocaine. A reasonable, logical inference would be that the drugs were inside the house, they were being moved from inside the house, and then sold at...
So the drug dealer, the house of any large drug dealer could automatically be searched because...
Well, not automatically. I think the facts would have to show that there is some sort of probable cause, as in this case. Probable cause does exist.
Probable cause that they're dealing in large amounts of dope, or probable cause that the dope may be located in the house?
I think both. I think there was probable cause that they were moving large amounts of dope. And, most drug dealers don't drive around town with large amounts of drug in their vehicle. I think most drug dealers have a safe haven where they do keep the drugs. And then at that point, when there's a caller that says, I want a certain amount of drugs, that drug dealer would then go, like Mr. Simpson did, and it's Mr. Watt's residence. Mr. Simpson would leave the residence, meet different buyers at different locations, and provide the drugs that they asked. And the police at all times surveilled Mr. Simpson leaving the residence, locking the residence, and then going in different vehicles and providing the drugs.
How do we know that most drug dealers don't drive around with lots of drugs in their car and instead keep them in a safe haven and keep their home?
I think the inference would be that, in a vehicle, you're more likely to get stopped and searched, and therefore stopped, and the police could then arrest you. In a house, there's more restrictions by the Fourth Amendment, which do not allow as easy of a search as they would in a vehicle. And furthermore, the state would also rely on,
Well, let me keep you at that argument for a minute, because I sort of pondered that argument as well. And I mean, to some extent, the argument becomes, I can search the house because a reasonable drug dealer wouldn't keep the drugs in the car because it's easier to search the car, and that's why I get to search the house. It seems to be sort of circular.
well, not necessarily that. I think it depends on the facts that the police determine, and then they provide to a magistrate to issue the probable cause search warrant. I think the magistrate has the ultimate decision, and in this case, the magistrate did sign the warrant and gave the police the authorization to search the residence. And there is cases out there which kind of have somewhat of the same facts. In State v. Siegel, the police received an anonymous tip informing the police that the defendant wanted to establish an indoor marijuana growing operation. The police examined FPL records, recent purchases, and did a flyover, and that pieces fitted neatly together to support the conclusion that contraband or evidence of a crime would be found at the residence. That's what we're arguing somewhat the same. Police did provide surveillance of the residence. They did determine a probable cause existed to conclude that drugs were inside of the residence based on Mr. Simpson's activities. Police also, through their own searches, found out that the residence belonged to Mr. Watson when he purchased the residence in 1032 Bernice Road in 2004. The logical conclusion, again, is that drugs were inside the residence. In State v. Harris, a bug on the CI and a confidential informant was heard by police were monitoring. Confidential informant claimed that drugs were in the house. The conversation between a confidential informant and the drug dealer consisted of the drug dealer telling the confidential informant, I do not sell drugs in the house, rather would meet them at certain different locations on Jackson Street, clearly implying that drug sales occurred. And the trial court granted the motion to suppress. The appellate court found that a good faith exception applied. It was not so lacking in the indicia of probable cause, which is...
Now, the controlled buys that were the subject to this investigation were not from this defendant, correct?
No, they were not. They were from Mr. Simpson.
Okay. So focus on those ties specifically to Mr. Watt.
Well, the ties would be the police did survey the residence. We're watching Mr. Simpson as he would always exit the residence, get into his vehicle after the confidential informant placed phone calls to Mr. Simpson. Mr. Simpson received the phone calls inside the residence. He would then enter different vehicles on two different occasions and provide the quantity of drugs that the confidential informant asked for. Logical inference is drugs were inside of the house.
So you didn't need anything. You didn't need your confidential informant to say Watts was involved in the drug dealing?
Well, the confidential
Mere fact that he lived there or owned that property, would that have been enough to get the search warrant based on what they saw with Simpson?
Well, I would still argue yes, but in this case, what we have is confidential informant saying that Mr. Greg Simpson and Joseph Watts sell large quantities of cocaine in and around the Brevard County area, and that they do not allow buyers to come to their house and purchase the drugs, clearly implying that Mr. Watts was involved in the operation.
Help me with the facts now. What weren't the facts in the affidavit that both of them lived in this residence?
Yes, Your Honor. The confidential informant, however, could not provide the specific residence, and then through investigative means, the police unit was able to determine where the residence was, who purchased the residence, who lived in the residence, who was Mr. Simpson and Mr. Watts. Furthermore, in State v. Wells, for a search warrant to be valid, it is not necessary that there exists direct proof that the objects of the search are located in the place to be searched. If there is probable cause to believe that someone committed a crime, then the likelihood that a person's residence contains evidence of the crime increases, and that's directed from Professor Lefebvre. And then, of course, we have a case, State v. Felix, which was recently decided by this court, which is somewhat of a different child pornography case, but I think the logical inference would be somewhat of the same. Trial court found that the affidavit did not provide a sufficient nexus between the residence and the computer. Proper question was whether a fair probability existed that the evidence or fruits of the criminal wrongdoing would be found there. Reasonable inference was that the suspect would keep images on a computer inside of the home. And this is the same logical inference that the state is making.
Wasn't the affidavit in that case, wasn't there some evidence in the affidavit that from the officer who investigated child pornography cases that people who trade in that sort of thing typically store them on the computer?
Yes, sir.
Don't get rid of them?
Yes, sir.
And isn't that somewhat similar to the evidence that's not present here, where I think it was Judge Griffin's question about what evidence is there that drug dealers typically keep their stash at home versus a car or a storage unit?
Well, We would argue that the facts do show that the logical inference where the drugs were kept there. Again, the confidential informant stated that there was large quantities of the drugs that were being moved in and around the Brevard County area, implying that Mr. Simpson and Watts were collaborating in this endeavor. Large quantities of drugs usually are not kept in the vehicle. Large quantities of drugs usually are kept in the residence. There was probable cause when the police officers observed Mr. Simpson on 2 different occasions leaving the residence and providing the quantity of drugs that he caused. Again, a vehicle is more susceptible to be searched versus a house.
Now, did the affidavit contain any statements to the effect of what you just said, that being drug dealers would typically keep large amounts of drugs in a house rather than in a car?
Well, Your Honor, the actual affidavit does not contain that, but that's a logical inference that any reasonable person could make. I think my time is up. Thank you.
Good morning. Please, the court, counsel. My name is Keith Zahach, and I represent Joseph Watts. Respectfully, I submit that all sales and possessions of cocaine would provide probable cause to search a dwelling if we have only the facts that are listed in this affidavit. If we don't require more facts, then I submit all sales and possessions, you'd be able to get a search warrant for a dwelling.
Well, but is that really true? I mean, we know that the drugs either came from the house or the car, don't we?
No, I don't think we can say that.
Well, he left the house, he got in his car, he went straight to the Hess station, and he sold them some drugs. Didn't they either have to come from the house or the car?
Respectfully, I don't think we know that he went straight to the Hess station, and that was one of the points that I wanted to point out to this court. What we have in the affidavit is we have 2 deputies that are surveilling the house, and they see Mr. Simpson leave the residence and get in the first instance on February 10th, he gets in a blue truck. He leaves the residence. Those deputies do not have constant surveillance on Mr. Simpson. Now, there's 2 other deputies that are at the Hess gas station in the first instance, which is in a different town, and there's no evidence in the affidavit as to how far away distance-wise it is.
Well, it says less than 2 minutes later.
The affidavit says less than 2 minutes later.
So we have to, I mean, isn't it, if it's less than 2 minutes, even if we don't know although the locations are here, and it wouldn't be hard for us to figure out, I'm not familiar with Rockledge, but.
How do we know it shouldn't have taken 30 seconds, or maybe it was just around the corner? The affidavit.
I mean, that's fine, but we know maybe it should have taken 30 seconds, but it took 2 minutes. So, I mean, I think that's a reasonable inference that the place is pretty darn close.
I agree.
And that he didn't have the time to, drive off, go to a storage unit, go pick up the stuff, or go to, someplace else and pick up the stuff. I'm not talking about proof beyond a reasonable doubt. We're just talking about what reasonable inference can you draw from the fact that the police observe him coming from the house, get in the car, and 2 minutes later appear at the location that was agreed to on the telephone call for the hand-to-hand transaction.
I think it's just as reasonable to conclude, because the affidavit doesn't list the distance, and I know it's less than 2 minutes, but he could have stopped at another house on the way. He could have stopped on the corner on the way for 2 seconds and retrieved the package. I think it's just as reasonable to assume that he could have done that when the affidavit does not tell us it's 0.2 of a mile or it's 1.2 miles.
Well, if it's just as reasonable, is that fatal to the warrant? If we're talking about a probable cause standard, I mean, if it was equally likely that the drugs were in the house or in the car, would that be enough, or does it have to be more likely it's in the house than in the car? Because there's only one inference you can draw in any given case.
I think that if this court determines that there's a fair or reasonable probability that based on the affidavit that drugs were in the house, then of course the house or the car, I guess you could say it's equal. But taking what we have in this affidavit, I do not think it is equal. I do not think we should assume that the drugs were in the car. They could have. There were 2 alleged buys. There were 2 buys here, and on the second buy on February 16th, there was an unknown female that was with Mr. Simpson. And the affidavit indicates they saw Mr. Simpson leave the residence, but not the unknown female.
Or did the two controlled buys involve the same vehicle or different vehicles?
Different vehicles. The first one was a blue Dodge truck, and the second one was a white Honda, which apparently the unknown female was driving, because the affidavit indicates that Mr. Simpson was a passenger.
Doesn't that support, since there's no common denominator there, isn't there a reasonable inference if different vehicles were used for the drug transaction that the stuff wasn't stored in the vehicle, that it had to come from someplace else?
No, I don't think it supports that. I think it's just as likely that the drugs were stored in the vehicle. The affidavit doesn't indicate who owned those vehicles. Did Mr. Simpson own those vehicles?
Tell me why, the more intriguing part of this case to me is the application of the good faith exception.
Yes, sir.
And I've got to tell you that, I've looked at the affidavit a number of times, and, I think it's a close call. But I'm having a very difficult time understanding why the affidavit is so lacking in probable cause that even though an experienced circuit judge found that it had probable cause and signed it, that it was so lacking in probable cause that any police officer who looked at it would have known that this search warrant was no good.
Yes, sir. I would direct your attention to the affidavit itself, and let's start with Agent Anthony Brannon, who I know very well. Agent Brannon indicates his training in the affidavit. He indicates he's made well over 500 arrests, and he's attended training courses, one of which is lawful invasions, in parentheses, search warrants, which he took in November of 2003. And the law regarding good faith is good faith requires officers to have a reasonable knowledge of what the law prohibits. Now,
isn't that a fair inference that Judge Silvernail should have had a reasonable knowledge of what the law prohibits as well? But he signed it. I mean, would you agree with me that we should assume that Judge Silvernail has a reasonable knowledge of what the law prohibits?
Yes.
Okay. I know it'd be hard to go to Brevard County and answer that question any other way.
Especially since Judge Torpy may be listening, and he knows Judge Silvernail very well, as do I.
That's right. But understanding that dilemma that you're in, how can the officer who's taken, his 40-hour course and he's taken, courses on how to do search warrants and all that?
Respectfully, yeah. This officer's taken some detailed training, at least listed in his affidavit. He's done over 500 narcotics arrests. He's got narcotics identification and investigation.
So basically your argument is, if I understand it, is that the Leon exception doesn't apply, because if I went out and showed this affidavit to 10 experienced narcotics officers, they'd throw up their hands and say, no way am I getting a search warrant on this.
I think they should do that, and they should at least question, especially with 933.18, which says that the search warrant has to indicate that the violation of the drug laws are occurring inside the dwelling. So I think an officer that's supposed to know the law should have a question there and say, we got this statute that says the affidavit has to show that the drug laws are being violated inside the dwelling. We don't have that.
In which case he should do what? He should say, I don't care that the judge issued a warrant, I'm not going to serve it because I've analyzed the law myself and I think the judge is wrong and I'm right. Is that what he's supposed to do?
I think in order to rely on the good faith exception, he has to have the knowledge of what the law prohibits. So I think he needs to question that warrant and not just blanketly rely on the judge that he hands the warrant to. Who knows how long they were together? Who knows if the judge read every single word of the affidavit? I think he needs to question that. And I think he needs to read his affidavit carefully. Somebody that's so trained as he is should put much more detail in the affidavit. There's no sale of drugs from inside the residence. There's no evidence of any drugs inside the residence. There's no person inside the dwelling that has been said to be...
But Judge Silvernail didn't find any of those things to be fatally defective, right?
That's correct. He signed the warrant. I don't... Now...
So you've got two circuit judges who who understandably, I mean, reasonable people can differ on the same set of facts. We don't have any dispute over what the facts alleged are because we're all looking at the same affidavit. So I'm just trying to understand, I mean, if we accept I think that Judge Davidson and Judge Silvernail are both reasonable people. Probably agree with that, since you have to go back to Brevard.
I would agree anyway, they are.
And, you know, so if we accept the premise that reasonable judges might disagree on this, and again, I'm having a hard time with the idea that how Leon doesn't save it unless, I mean, I thought the whole idea of Leon was that, you know, if it passes muster with the judge, unless it's so bad that anybody would know that it's no good, that it's okay. The judge is supposed to be the gatekeeper, and he served as the gatekeeper here, although he may have been wrong.
I don't think, two things that you just mentioned that I'd like to talk about. One, whether there's a dispute as to the facts in the affidavit. I think there might be, and I'd like to get back to that. But you said anybody would throw up their hands and say this warrant's not good. It's this particular deputy who has the training and the experience.
Isn't it an objectively reasonable officer? It's not this particular officer, right? It's not a different standard if the officer who gets the search warrant has less training than this guy.
It's objectively reasonable, yes, sir.
So really, the experience and training of this particular officer is irrelevant.
I don't
Because
think
to do otherwise would require us to apply a subjective test, and you agree with us that it's the objectively reasonable test under Leon.
I agree that it's objectively reasonable, but I still
So
think
tell me now, let's go back to why you say that we're all not on the same page as far as the facts. We've all looked at the same affidavit.
yes, sir.
And I didn't see any evidence that there was, that Judge Silvernail's elicited testimony from the officers that wasn't contained in the affidavit.
That's correct. What I dispute is whether Mr. Simpson lived in the residence. Now, I know there's one of the CI's claims that Mr. Simpson and Mr. Watt reside in this residence together. I don't think we should take that as a blanket true statement. The deputy, in my opinion, did not do enough to confirm that. He does say in the affidavit that he saw, based on some surveillance, and he doesn't indicate how many surveillances, he says that he saw Mr. Simpson exit and leave the residence with using a key. So what? Respectfully, so what? I mean, my mother-in-law has a key to my house, and she exits and comes into my residence. Doesn't mean she lives there. He doesn't indicate whether he sees Mr. Simpson spend the night. Doesn't indicate whether there's anything about
Was the issue whether he lives there or whether it's reasonable inference that the drugs are kept there? Isn't that what leads to your ability to search the house? Who cares who's living there or who owns it if there's a reasonable inference that you're going to find drugs if you...
Because with these particular facts, I think it is important to take a look at whether Mr. Simpson lives there because of the observations of the officer. Because when Mr. Simpson leaves the residence, there's nothing in the affidavit that says, I saw him with a bulge in his pocket, or I saw him carrying a bag that looked to have cocaine in it. There's nothing in there about the clothes that he wore. We talked about a large quantity of drugs. How do we know it's a large quantity of drugs? They use the word large. The affidavit doesn't indicate what the amount was when they retrieved the drugs. Was it an amount too large to carry in clothing in a pocket that you would see it when he left the residence? These are all things we don't know from this affidavit. And that's why, in my opinion, the affidavit is clearly lacking, and the good faith exception should not apply. Some of the other cases talked about trash pulls. There's no trash pulls in this. We don't have any evidence of whether the drugs are connected to this residence. Are they connected to Mr. Simpson? Sure, Mr. Simpson's the one that had the drugs on his person, presumably. We don't know that either. Another thing that's lacking from the affidavit is when the CI went into the vehicles on both occasions, where were the drugs? Did Mr. Simpson take them out of his pocket? Were they in the glove compartment? Were they in the center console? Were they on the floor? We don't have any of that.
Would the facts, as alleged in this case, be sufficient to get a warrant to search the car? Since you said it's a more reasonable there'd be a more reasonable inference that the drugs are kept in the car. So could they get a warrant for the car on this?
Probably. I would say yes for the car. I don't like to concede that, but, I mean, we have the sale occurring in the car on that particular occasion. Is it reasonable to assume that there's additional drugs in the car? I don't know. But, I have not much left, but I want to respond to Judge Griffin's comments about what do we know about drug dealers? Do they keep drugs in the house, or do they keep them other places? I would respectfully submit to you that if Deputy Brannon were here, based on his training experience, he would tell you that in many cases, drug dealers don't keep drugs in their homes or in their residences or where they stay for the purpose of search warrants. And if somebody comes to search the house, I'm not going to have it there. I haven't found any cases that say that. I haven't found any cases that say the opposite, that say that experts have agreed, like the computer case with the pornography. Experts talked about that and where computers are. They're in homes. We don't have that evidence in this case. We don't have evidence that those that possess and sell drugs keep them in their homes. And I think for that's one of the reasons.
Could the detective testify to that in an affidavit, presumably based upon his experience?
Can one? Sure. If they have if they've done the proper surveillance and they've had sales occur inside the residence, where they could say the sale occurred in the residence, then I think sure you get a search warrant to
No. How about more generally? That is, I've worked 500 cases, and
yes,
it's more likely in most of those cases when you have large-time drug dealers, they keep their stash in their homes, not in their cars.
I think
That would have been enough. And that's what's missing from this affidavit?
I'm not saying that would be enough and would get you over the edge, but that's sure
Enough to add to what's already in this affidavit. If this affidavit had added that paragraph.
I think that's a fact that should be, that would help if that was in here, yes. I think my time is up. I
It is, but I have one other question for you. In a situation like this, is a trial judge entitled to use what he knows factually? For example, if the trial judge knew the distance between 545 Barton Boulevard and 1032 Bernice Road, is he entitled to use that?
Interesting question. My answer would be, obviously the judge needs to rely on the four corners of the affidavit, but they also get to use their common sense and the totality of the circumstances. Now, if you have to rely on the four corners, but you're allowed to use your common sense, if part of your common sense is you know the distance, I don't know the answer, Judge. I would. It's not part of the affidavit, so if you stick with you have to rely on the four corners, and the answer is no.
Doesn't the evidence code allow the court to take judicial notice of matters that are not reasonably subject to dispute?
Does the evidence code?
Yes. I mean, so the court could take judicial notice of matters that are not reasonably subject to dispute. And, wouldn't you agree with me that, the location of those two places in Brevard County are not subject to reasonable dispute? Now, I might not know, I don't know them, but if I lived down there or if I had a map in front of me, it'd be easy to I could pinpoint them in 2 seconds.
Right.
In other words, they are where they are.
They are where they are.
But now you're assuming Judge Silvernail did that before he signed the warrant.
No, I'm just saying, the question that Judge Griffin asked is the judge entitled to use things that he knows? And I'm saying is, if those things are beyond dispute, they are where they are, if he knows it, doesn't the evidence code allow him to use it?
Yes.
Okay.
Thank you, counsel.
Thank you.
Again, the state would argue that the warrant was not so lacking in indicia of probable cause as to render the warrant invalid. Alternatively, even if the warrant was not sufficient ground of probable cause, the good faith exception to the exclusionary rule does apply.
Talk to me about the Rankley case, which is the case out of the first DCA where they observed the guy leaving the house with the white box. Is that bad law that we ought to disagree with, or is it simply distinguishable on the facts?
I think it's distinguishable on the facts. Officer did not have actual knowledge that drugs were present in the Rankin case. He was just relying on a middleman who told him that he can get drugs from a source, and there was never any surveillance done, or there was, but it was past surveillance on the residence, never any actual surveillance. So I think
I thought there was surveillance, and they saw they saw the guy leave the house with a white box, and then when they did the controlled buy, the drugs were in the white box.
Right. There was surveillance.
And they
not
said the
actual
defect
residence.
was you couldn't prove that when he walked out of the house with the white box, it had the drugs in it that sometimes later were delivered in that same white box.
Right. Again, I think the facts are different because the affidavit did not allege and show reliable connection between the middleman's activities and the appellant's home in the Rankin case. Here, I think you have the connection where you're observing Mr. Simpson leave the residence, provide drugs at different locations to different confidential informants, and Mr. Watts owned the residence. It's a logical inference that there was drugs inside of the residence. Again, we would argue that the good faith exception does apply. There was no evidence deduced in the affidavit to establish bad faith on the part of the officers, misrepresentation, any material omissions of fact, to say that the police acted unreasonably in reliance on the warrant. And the appellee cites the Bonilla case, but the Bonilla case is very different in where the police officer actually omitted a crucial paragraph which established probable cause. Finally, the warrant was based on probable cause to suspect that Watts' residence was being used as a drug haven to transport and store drugs for sale in and around the Brevard County area. There existed a fair probability that drugs would be found inside of the residence based on police surveillance of the residence and of Simpson. Alternatively, the good faith exception was applicable. Therefore, the state would ask this court to reverse the trial court's order suppressing the evidence. No further questions from the panel.
Thank you, counsel.
Thank you both.